I'm talking today with Robert J.L. Moore, an IP attorney with Volpe Koenig. We're here today to talk about a new pool from Avanci, the Avanci Video Pool, that's targeted towards streaming companies that are providing internet video streaming to its users using any of these five standards: H.265, H.266, VP9, AV1, and mpeg-dash. Thanks for joining us, Robert.
My pleasure.
Let's start out. Who is Avanci and what other pools do they have?
Avanci's a company that was founded 7 or 8 years ago by a parent company called Marconi. And it's in the business of offering patent pools for non-traditional applications of specific standards. So Internet of Things is one vertical that they've gotten into rather heavily. Automotive is a second one. So their first batch of pools were directed to 3GPP standards. Those would be cellular standards like 4G. Automotive was an emerging use case for that standard, and that was the vertical that they launched with. Now they're seeing, I understand from what they've said publicly, that Marconi perceived that there was a need to address risk that content providers were taking on with the full contingent of video codecs as well as mpeg-dash, and that's what they're seeking to fill with this.
Okay, how would you gauge their success in the IoT and the automotive markets?
They have licensed most of the automotive segment to at least 4G and probably 5G as well. So those pools, they were rather slow to start. I should recharacterize that. It took a while to educate these new segments about the need to take licenses specifically from pools. These automotives were simply not used to licensing that way. But once it got going, and now it seems like those are very successful pools.
Okay, so I'm sorry, the language that you used is they created these pools to allow companies to minimize risk. Could you go into that a bit? You're posing this as a positive, and I'm guessing a lot of the people listening to this are thinking it's a negative.
Yeah, sure. If there is implementation of a standard and that risk is not licensed or otherwise authorized, there's a risk that the implementer could get sued. Now, that risk is cabined in many cases by things like the FRAND obligation or even just simple business considerations, one party not wanting to sue its customer or not wanting to sue a rival for fear of a lawsuit and reprisal. All that said, there are parties that will make it their business to go and exact the cost for their investment in creating a standard. That risk can be accounted for in multiple ways. It can be accounted for bilaterally. That's the traditional way. And secondly, patent pools can provide the market with an easier way to account for that risk, more transparent. It can be more of a level playing field, and it can also, from the licensor's perspective, provide returns that are predictable and regular.
Okay, and when you say bilaterally, you mean do a direct deal with the targeted company?
Right.
Okay. So talking about the new pool, I've already listed the covered technologies. There's 265, 266, VP9, AV1, and mpeg-dash. mpeg-dash is kind of, there was a pool for that with mpeg-LA back in, I want to say the late teens. What happened with that, and where are we with that now?
I think that pool is defunct. I'm not sure if that mpeg-LA pool was dropped before or after mpeg-LA merged with VIA. But I think that I think Avanci thought that it made sense to include mpeg-dash along with the other codecs because the people that they were trying to license would probably want to clear all that risk at once.
Okay. And I kind of talked about this. Do you have any detail on the internet video streaming companies? That's who they seem to be targeting. Any expansion or any detail or explanation there?
About their specific identity?
Yeah,
Right.
who would, are they going after, they going after CDNs? Are they going after publishers? Are they going after service providers? Or is it, all the above?
I don't know if there's a definitive answer on that. I do recall reading something that among the targets would be the OTTs. I'm not sure that's the extent of it.
Okay. What do we know about royalties applying to content? I mean, there's been somewhat of, I guess, looking back with mpeg-LA, they said with 264 it didn't apply to content, and the two, I guess the HEVC pools both don't have content or don't have royalties on internet streaming. Is there any kind of, what's the legal status of royalties on content?
Well, traditionally, patent pools, as you mentioned, identified one part of the value chain for the feature of video compression to go and push all the royalties onto, under the thinking that the rest of the universe that was perhaps also implementing that standard would go and adapt accordingly. So if the devices are paying for the feature of video compression, then and the streamers are not, then perhaps that can be accounted for in other ways. There could be bilateral agreements, for instance, between the streamers and the device OEMs for a certain percentage of revenue every time a subscriber signs up using the device OEM's device, right? That's actually a fairly common way to account for that. But now we are seeing an increased move to isolate the patent risk for content providers. We're seeing there were some lawsuits in the relatively recent past. There was an injunction in Germany against, I actually don't have it in front of me, but I believe it was Netflix, and that was using standard essential patents for HEVC. And there's an increased perception, I intuit, on the part of licensors to say that perhaps not all of the value, not even close to all the value of the feature of video compression is captured by the device OEMs. Increasingly, more and more is calculations or encoding, transcoding, and decoding is happening in the cloud and not on the device. So maybe it doesn't make as much sense to have the devices be the only port of call for patent royalties.
Okay. What percentage, there's only about 25 licensors in the pool, and I know there's dozens in, the HEVC pools, the H.264 pools, and even the SysVal, VP9, and AV1 pools. So what's your assessment, and I don't need detailed numbers, but, what percentage of overall patents do they have in their pool that relates to these codecs, and what happens if they don't, what happens with licensors that aren't represented in the pool?
I thought this was generally an impressive list of initial licensors. You have a lot of major contributors to various codecs. So LG had a strong position in HEVC. They're part of the initial licensors. Huawei, on the other hand, they were one of the leading contributors to VVC, and they're part of the initial contingent as well. So you have a mix of licensors that you probably would want to clear the risk from. I can't tell you what the percentage of any given codecs SCPs are represented in this list of licensors, but it's generally true, and I think it's probably going to be true here, that the list of licensors grows over time, and the price doesn't change. So if you were a licensee and you signed up today, the price that they're giving you is what Marconi believes is a fair price for the feature of video compression, understanding that they're probably going to get more and more patent coverage over time.
Okay, and was there a price on the website? Last time I looked, it wasn't there. Has that been added, or do you have any insight into what the price might be? Even how they might calculate it?
I don't have any answers to that. I don't know if they're still working on it, or if it's just something that they're not publicizing. I know with the other Marconi video codec project, Velos Media, the actual royalties they were seeking were never public. So it could be the case here. I don't know.
Okay. I mean, their website said it said they weren't available yet. I don't know if they're going to publish them or not.
Yeah.
So what happens now if you're another patent pool, if you're the Access Advanced pool, and you've got patents in your pool that aren't covered in the Avanci pool. Are you going to expand to content, or what's your sense of that?
Well, Access specifically, I think, is not. Access, when it launched its HEVC pool, sought content royalties, and the market didn't appreciate that. Now, honestly, the royalties they were seeking were, I would say, relatively insignificant compared to what I expect Marconi's going to seek. I think it was somewhere in the neighborhood of $1.5 million a year as a cap on the royalties that HEVC Advanced was seeking at the time. So, and I'd expect Avanci to seek more than that from the likes of Netflix or whomever. But Access Advanced, I think, is going to continue as a going concern and licensing the device OEMs, clearing risk there. So, and clearing risk specifically for HEVC and VVC, setting aside the other codecs that Avanci is going to cover. And then I know that there have been that the Avanci pool was architected in a way to work around the rights that were being granted already by Access Advance and probably by Via LA as well. So if you have a license to one, there shouldn't be commingling of the rights that you would get with the other. That's their intent for sure. So
they're not
realistically, you may have, if you're a company, I'm sorry to speak over you, but if there's a company that has both content and device implementations, let's say Google, for instance, it may make sense to take licenses to both. Google being a member of HEVC Advance, they may also elect to be a member of the Avanci pool and clear risk that way.
Okay, so bottom line, Avanci is not going to go after decode, and as far as you know, decode is not going to go after content.
I'm not sure about that. So the standard is directed. All these standards are directed to the bit stream. And traditionally, that meant that the implementation that was actually licensed was the decoder. There could be additional implementations that are covered by the standards, but I think what they're trying to do here is license OTTs, just to give the use case that I know they're going to go after for on the one hand their transcoding activity. So there's frequently some in the course of the OTT's transmission of a compressed video. There's transcoding from a storage format to a mezzanine format, then to an eventual delivery format. That can have some implementation of these codecs at issue here. And then separately, the actual storage of these files themselves does involve encoding and decoding as well. So there could be some implementations of the standards in that respect.
Okay, so you think all this is going to be litigated, or do you think everyone's going to just accept, or when I say everyone, the companies that may be affected will just accept it and go on? What's your sense of where the law is and how likely it would be that they could prevail if they decide to challenge this?
There were a number of companies, despite the Avanci 3GPP pool of successes, that challenged that pool's rates in court. So they were challenging challenging whether these complied with FRAND obligations, setting aside the issue of whether there was a FRAND obligation that Avanci had absorbed because it was the licensor of patents that were FRAND encumbered. Setting that aside, I think that was generally answered. I think courts generally found that Avanci had met what obligations it may have had. Then, are people going to walk away from that experience and say, okay, they did their homework once, are they going to do it every time? Probably not. I'd expect there probably will be some challenges, and I think there'll also be gradual success for Avanci. I think it's a good group of people over there who know what they're doing and typically will work with licensees before they launch a program to see what the market will bear.
Interesting. You talk about FRAND a lot. Of course, VP9 and AV1 are not standard standard essential, or based on standard essential patents. So what happens there?
Well, I mean, that's part of the risk that I think Avanci's trying to clear. There is no FRAND encumbrance on those patents from companies that didn't participate in the creation of those codecs. So there's less of a limitation on what a company, a standard essential patent holder for those codecs could exact in royalties. So that being the case, there's more risk there, and it makes sense from Avanti's perspective to offer content providers an opportunity to clear that risk.
Okay. So does this mark some kind of a sea change? I mean, if you've been not, for example, if you've not been assuming that you were going to end up paying royalties, did all of a sudden your financial people come and say, hey, we've got to start, accounting for this in our revenue and expense, or, do you think that's far off?
I'm going to go in the middle here. This is a sea change for the MPEG codecs, in the sense that there may still be some opportunity, but there was at one point an opportunity for content providers to get a free covenant not to sue from Access Advance at least, and I could be wrong, but I believe that Via LA had a similar program. So that, in that sense, implementations were free, and bear in mind that HVC Advance in particular had a critical mass of the rights that you would need to license if you were a content provider. So you may at one point have considered it free. If that in fact is going away, if that opportunity to get the rights you want for free is going away, then that is a change. And I note that there are, by my count, 5 or 6 companies that are amongst the list of the initial licensors to the Avanci pool that are also part of the Access Advance pool. So,
Well, if I got that get out of jail free card from Access Advance, am I going to have to pay royalties under the Avanci pool if I already have clearance of that risk based on what I signed with Access Advance?
I would imagine that these covenants not to sue are, if they're not for a specific term, they could be for the life of the patents or something else. But there is going to be at least a period of time where what rights you were granted by Access Advance in this covenant not to sue are going to persist. That said, that's not all the rights that are going to be granted by the Avanci pool. And I'll just say this, just to finish my thought here. This is not a sea change for the VP9, the VPX suite, including AV1. If you were a content provider that thought that these codecs were going to be free and have no patent charges associated with them, then you were mistaken to begin with. And now there's an opportunity for you to clear that risk. That's how I would understand it.
Okay, so I guess if you're a publisher, you either call Avanci or you call your attorney. Is that kind of the choices at this time?
Why not both? Yeah, you should understand what codecs are going to be implemented and what risk that presents. Not just presented today, but presented over the next X number of years. And then make plans to account for that risk. Because I guess the larger point is the universe is moving to seek royalties from content providers. I guess that is a shift.
So Robert, what does this do to companies selecting codecs going forward? How do you see this affecting that decision?
Well, from the OTT's perspective, I think it takes the question of which codec has a patent cost associated with it off the table, because now they all do. I guess the Avanci pool is, as I understand, intended to create a level playing field in the sense that there's going to be a patent cost associated with each of the codecs, and you may as well choose the one from the OTT perspective. You may as well choose the codec that works best for your needs. It used to be the case that I guess prevailing wisdom at one point was that they may have to pay for the MPEG codecs, but not for the VPX suite of codecs, including AV1. I don't think that's going to be the case going forward. I hope that the OTTs draw the appropriate lessons from this announcement that they are going to have to pay something.
What about the Alliance for Open Media and their, their legal defense fund? What do you see happening from them in this case?
Yeah, it could be the case that they fight against this and they fund some litigation against what Avanci's trying to do here. So patent litigation though is extremely expensive, and if you were, for instance, to launch let's just pick a random AOM member. If you were Google and you were trying to dispute whether you had to pay any royalties to Avanci, and you're embroiled in litigation in the United States, in Germany, and in China, I would expect you'd be committing upwards of $30 or $40 million to that litigation. And if it's protracted, if it's over 5 or 6 years, you may double that or even triple that. That's money that is going to exceed any reasonable legal defense fund. I don't know exactly how much a legal defense fund is for AOM, but you're probably going to run out of money pretty quickly.
Okay. All right, listen, thanks for taking the time. This has been very educational for me and I'm sure for the people who are watching. You take care and thanks again.
Take care. Thanks.